let's go ahead and proceed.
Thank you, Your Honor. Your Honor, it's a fairly simple issue. We sent a second request for production to the plaintiff requesting copies of any and all LOPs, letters of protection they've issued in this case. And as Your Honor is certainly aware, the Supreme Court has not only said that LOPs are discoverable, but they're now also relevant. In K&L Auto Crushers, which a decision which was issued last year, the Supreme Court said that the existence of a letter of protection is directly relevant in a personal injury matter because providers treating a patient pursuant to a letter of protection have a direct financial stake in the resolution of plaintiff's claims. This was an extension of the decision reached in In re Cyprus. But Your Honor, not only is it relevant, but the only way for a defendant to find out where an LOP has been issued such that we can go to the provider and get the information is that it be given by the plaintiff's attorney or the plaintiff in response to discovery. So we're asking that you order the plaintiff to remove the objections in order to respond fully to the second request for production in which we've sought LOPs issued in this case because, as noted, the Supreme Court said it's not only discoverable, but it's relevant.
Ms. Watts?
Your Honor, the plaintiff requested the court deny the defendant's motion.
You're getting a lot of some kind of, I don't know, you're moving something or it's messing up with your mic. I can't hear you.
Okay. Can you hear me now, Your Honor?
Yeah, that's better.
Is it clear? Okay. The plaintiff asked the court to deny the defendant's motion to compel based on the argument that letters of protection are provided to protect the medical providers as well as the patient to receive treatment in regards to injuries received as a result of the negligence of the defendant. The letters of protection provide an opportunity for the plaintiff to receive treatment. Am I here?
Yeah.
I'm sorry, my camera just went totally black.
Oh, we can hear you and see you.
Okay. It allows the plaintiff to receive treatment as a result of the negligence and to allow the providers to be paid as a result of the lawsuit.
How do you distinguish? Yeah, how do you distinguish in re auto crushers?
I'm sorry, Your Honor.
How do you distinguish in re auto crushers?
How do I distinguish it?
Yeah, that was the case you just cited to.
As the relevance for when the providers, are you asking about the relevance of the case, Your Honor?
Well, yeah, so he cited the in re auto crushers saying that mandated the discovery of LOPs, and I wanted to know how you distinguish that case and why it doesn't apply in this case, if that's what your position is.
Yes, Your Honor. That case went towards the collection of discovery for insurance claims based off of, I'm sorry, let me pull this up. On the collection of insurance claims for different claimants. This case, our case is involving the plaintiff and her medical providers, not stating that the reasonableness and necessity of the bills of the providers are at issue here.
Ms. Watts, are you still there?
Yes, Your Honor.
Okay, yeah, you cut out again. So you're saying it's distinguishable because it's not a personal injury case?
Correct.
Okay. All right, response?
Your Honor, it is a personal injury case, and the Supreme Court has obviously stated, not only in In re Cyprus operating, but again in the extension of K&L Auto Crushers, that the discovery of LOPs is relevant and discoverable because it goes to the issue of reasonableness of charges, which are the standard for recovery is reasonableness and fairness, not just what was charged. And as the Supreme Court said, how can one know what's reasonable and fair and necessary without knowing what a provider charges everyone versus just in the LOP matter? And thus the Supreme Court has said again that the LOP, the providers that treat by LOPs, the LOPs are relevant to the amounts.
Can you share screen that case? I've read that case before. I don't I don't recall that portion of it. So if you can share screening it so I can take a look at it.
Well, Your Honor, I can't share screen it because I'm on a laptop, but I can give you the site and the page. And
Okay. Well, you're on a laptop. You should be able to share screen it.
well, my laptop is not connected to my system as part of the problem.
Okay.
In other words, I don't have LexisNexis on here, so I can't pull it up.
Oh, okay. Okay.
But you know, the site, Your Honor,
Okay.
is 627 Southwest 3rd, 239, and that provision is on page 254.
Okay. Let me see if I can pull this up.
And of note, Your Honor, in the opinion, the case remarks, here the defendant's in a personal injury suit. So it is a personal injury suit involved in K&L Auto Crushers.
Let's see. Okay. I'll go ahead and share screen the case. Okay, you say 254.
Your Honor, I think you've gone past it.
We're going past, okay. Okay, do it. I see. Okay, I'm missing the pages. There we go. All right.
You see the paragraph that we are sensitive to the fact that we agree that the status as to non-parties is relevant to whether the requests are unduly burdensome, but to promote the resolution of disputes based on what their facts reveal, not what the facts are concealed. Our rules specifically permit parties to compel non-parties to produce relevant information. And then it goes on to say, and because of this, and it goes on to say that unlike most non-parties, the providers who treated Walker, the plaintiff in this case, pursuant to letters of protection, invested themselves in the outcome of this case, the amount of damages recovered, and because of that,
but it isn't, if I recall correctly, isn't NRA Auto Crushers a subpoena to a, and maybe that's the case here, a subpoena to a third-party medical provider? It's not to the opposing party, right?
Well, that's correct, Your Honor, but it wouldn't make legal logical sense to say that an LOP to discover what an LOP from a medical provider states if I'm not entitled to the LOP in the first place, which is what the case says. The LOP is irrelevant.
My point here is that in NRA Auto Crushers, it was a situation where they were subpoenaing the third-party medical provider, and the court found the letter of protection was discoverable. I agree with you there, but there's also an issue, and I think it's discussed right here, about whether or not, and I'm not saying it is, it isn't an issue. We don't know at this point whether it would be unduly burdensome to comply with it, because obviously under NRA Auto Crushers, you still have the you have to show, for example, that whatever you're requesting is not unduly burdensome to the third party. This is not a situation, but what you're doing here is you're requesting it directly from the plaintiff. Is that my understanding?
Well, all we've requested are medical providers, the LOP issued to medical providers in this case. And from there, we will then.
But the request is to the plaintiff, not to
Yes.
the provider, correct?
That's correct, Your Honor.
Okay, that was the only point I was trying to make. And so,
Yes, Your Honor. And from there, we'll issue a subpoena to the third-party provider based on the LOPs, because we'll then know who's treating the patient or the plaintiff under the LOP. And as stated, if the court's clearly saying that LOPs are relevant and discoverable, and it would be illogical for the idea that we can't get the LOP itself from the plaintiff so that we know which providers to subpoena versus subpoenaing every provider.
I guess, Ms. Watts, do you have any actual letters of protection? Do you actually have the letters?
No, Your Honor.
You don't have the letters?
No.
Okay.
Letters of protection would not be something that would be disclosed with the medical records. That's not something that we request from the providers along with the medical records and billing affidavits.
Yeah, but I guess my question in response to Your Honor would be, is she stating that there are no LOPs or they haven't produced them, which is obviously a difference?
No, Your Honor, I'm stating that we do not physically have LOPs.
Has the plaintiff, Your Honor, treated under an LOP issued by this firm or any other firm for the injuries claimed in this case?
Do you know, Ms. Watts?
Yes, Your Honor, she was treated under letters of protection.
I mean, Mr. Davenport, this is kind of a brave new world, obviously, with in-ray auto crushers. I will tell you that prior to in-ray auto crushers, I never would have ordered a LOP to be produced. But I agree with you that at least it's probably discoverable from at the very least from a third party. How many providers do we have here?
4.
Okay. All right, I'm going to order Ms. Watts, if you have any letters of protection, I think it's probably going to be discoverable if you have them in your possession. If you don't have them in your possession, just say I don't have any in my possession. And then if Mr. Davenport wants to conduct discovery as to the third parties, he can. Just get me an order to that effect, Mr. Davenport, and share that with Ms. Watts. Make sure at the beginning of the order it says that this was heard on May 16th, 2022. And then email that to my court coordinator, Rhonda, as well as e-filing it. Okay?
Will do, Your Honor. Thank you.
Thank you, Your Honor.
They would be excused.
You may. Mr. Jaycox, are you here for the dismissal docket?
Yes,
Okay. Are you here on Simmons Bank versus Hill?
that's correct.
Okay. What's going on with this one?
My process server contacted me on Thursday of last week and said they had filed a due diligence affidavit. And I'm having trouble logging onto the docket. I can't see whether they did or not, but I've engaged a process server, and I was in touch with them last week, and they said they had taken care of what they could.
I mean, if you're going to file though a due diligence affidavit, you'd have to accompany that with a motion for substituted service, right?
Right.
And have you all done that or not? I mean, I'll look it up right now, but
No, I haven't filed a motion for substituted service because they just got me the due diligence affidavit last week. I think it was Thursday or Friday. I don't recall which day.
Okay. I thought you said they filed it already.
Well, that's what she sent. That's the email she sent me, but you're right. I don't think that they can actually file that. It's dated May
Oh,
the
they
10th.
did file it, actually.
Oh, okay. Okay.
All right, we'll give you 30 days. You need to get a subservice on this. Take a look at the affidavit of due diligence.
I'm
And
looking at it now.
all right,
Thank you.
30 days and just get us a subservice.
Thank you.
Thank you.